Thank you, Peggy. Welcome to, it is February 9th, and it is 5:32 in the afternoon. And this is the first official meeting of the Joint Committee on Judicial Retention. Our members are all here. Tonight we have with us Judge Durkin and Judge Finster, who will visit with us and have a discussion as to why they might want to continue to be retained on the bench, the Superior Court bench. I'm sure our members will have some questions for the judges this evening. We did receive a report that Judge Carrie Ann McDonald Katie had a family emergency and will not be able to be with us tonight. I thought it would be the most courteous thing is to let things play out in her family life and not have any input from the committee as to other than hopes for a good resolution to her family issue. So we will, maybe at the end, we will talk a little bit about next week and trying to add her to the list with 3 judges that we'll visit with next week. Right now, I think we'll start with introductions for the judges. And Eric, do you have anything to add? Is there anything that we need to speak about?
The only thing that occurred to me, and I'm sorry I didn't mention it earlier, and you may recall it anyway, is that the rules of the retention committee do require that all the witnesses be sworn. So you probably remember that from previous years.
Okay, and you will do that honor for us. Am I correct?
I certainly could. Ordinarily, it's a committee member, but I'd certainly be happy to if that's preferable. Whatever the committee's
maybe we should delegate that to Senator Benning, who is quite familiar with the oath of affirmation. Or so, are you willing to do that for us, Senator Benning?
I think I can handle it.
Okay, I figured you might. Okay, so we'll go with introductions. So Dick, you're on my immediate side here, and we'll start with you again.
You want me to introduce myself?
Yes, please.
Okay, I'm State Senator Dick McCormick. I represent the Windsor County District, which is Windsor County and Londonderry and Mount Holly. And I've been on this committee for a few years now. And I'm looking forward to meeting with you.
Great. Thank you. Alice, you're next to me on the other side.
I'm Alice Nitka. I live in Ludlow. I represent the same district as Senator McCormick, and I'm the vice chair of the committee.
Thank you. Joe, you're next to Alice on my screen.
Good afternoon, judges. My name is Joe Benning. I'm a state senator from the Caledonia County District, which is all of Caledonia County and the 6 northeasternmost towns in Orange County. I chair Senate institutions, and I am a member of the Judiciary Committee as well.
Thank you. Ruth?
Chip, my name is Ruth Hardy. I'm the senator from the Addison District, which is all of Addison County, plus Huntington and Buell Score. Nice to be here tonight.
Thank you. And we'll go to the folks in the room. And to my right is Butch.
Good evening, everybody, and thank you for being here tonight. My name is Butch Shaw. I live in Pittsford. I represent Brandon, Pittsford, and Sudbury, and I serve as vice chair on House Transportation.
Thank you. And Celine?
I'm Representative Selena Colburn, and I represent Burlington's Chittenden 6-4 district, which, if you're familiar with Burlington, is the district where UVM and the medical center are, and then many of the surrounding neighborhoods. And I serve on the House Judiciary Committee.
Thank you. And I'm Representative Chip Troiano. I represent Caledonia 2 District in the Northeast Kingdom, Hardwick, Stannard, and Walden. I'm the chair of this Joint Judicial Retention Committee, and I'm the vice chair of the General Housing and Military Affairs Committee. I'd like to welcome both of our judges this evening. With no further ado, we will call on Judge Durkin. You are our first.
We have to do the oath.
Oh, yes, okay. Senator Benning will swear you in, Judge Durkin, if you mind.
Actually, Chip, would you like me to swear in both judges at the same time?
Sure, that would be a good suggestion. Yes. Judge Feinstein, yeah.
Gentlemen, if you raise your right hands, you solemnly swear that the evidence you shall give about the matter now under consideration shall be the truth, the whole truth, and nothing but the truth, under pains and penalties of perjury.
Yes, I do.
I swear.
Thank you.
Okay. Thank you, Senator Benning. Anything further from the committee?
I think we'd like to,
Okay, hearing nothing.
I'd like to
Hearing-
introduce Eric and Peggy Delaney, if we could, please.
Oh, yes, okay, sure. I'm sorry. Eric?
It's okay. Yes, good afternoon, Judge Durkin, Judge Fenster, Eric Fitzpatrick, and legislative counsel for the committee. I know we've communicated via email over the last several months, so it's nice to see you in person, so to speak.
I'm here.
Hi, my name is Peggy Delaney, and I am the committee assistant for Senate Judiciary. And I've been staffing this committee for, I think, 6 years now. And I get to see Judge Zone a lot in my committee. So thank you.
Okay.
Thank
And
you.
so I do see that Administrative Judge Zone is here with us, as everyone can see, Terry Corsones and Attorney Robert Paolini. And I see sitting in as Judge Mello, Judge Pack, and Judge Tour, who are due to visit with us next week. So at this point, Judge Durkin, you've been waiting. We will turn the mic over to you.
Well, thank you, Chair Toriano. I very much appreciate the opportunity to visit with you this afternoon. If I may, I have just a few brief introductory comments so you can get to know me a little bit. First of all, I want to let you know that I seek retention for the judicial position I began over 17 years ago because I continue to love my job. I am honored by the opportunity to continue to serve our state and to help bring about the orderly adjudication of land use disputes. Now, when I first became a Vermont attorney 37 years ago, I had little idea that I may become a superior judge. Way back then, I was hoping to understand the law and to help serve my community. Now, when I began that process, volunteering to serve on town, school, and state boards and committees was just the beginning of my appreciation of all that goes into making a town, county, and state run more effectively. When I was appointed to be the chair of the Act 250 District 2 Environmental Commission, down in the southeast corner of the state, first by Governor Dean and then by Governor Douglas, I realized how much I valued the adjudicative process of resolving disputes, particularly in a land use context. This is why I chose to pursue an appointment to become an environmental judge. Prior to my appointment, the environmental court did not enjoy a good reputation. It was understaffed and underfunded. The Permit Reform Act of 2004 brought more jurisdictional responsibilities to our court, but also brought needed additional funding, support staff, and a second judge. That was the position I was nominated to fill. I am proud of the efficiencies and understandable procedures that I have helped establish for our court. When I first started, I was handed a notebook containing a list of the outstanding cases awaiting adjudication. That list was single-spaced and 24 pages long. While I continue to seek out ways to further improve our processing times, I am happy to report that our under advisement list usually takes up about a half a page for each of our two judges. Whenever a major project or a major environmental impact is presented to a community, the best outcomes may only occur if all parties are given a fair opportunity to present admissible evidence and legal arguments. I am proudest of my work when I can facilitate that and provide a decision that is clear, based on credible facts and the applicable law, and also reinforce the precedent that can be relied upon in evaluating future disputes. Now, today marks the third occasion that I have appeared before this committee, seeking retention for another 6-year term. I am honored to have the opportunity to continue to serve our state. Believe it or not, I am grateful for the opportunity to go through this process again. Our country uses 3 different means of selecting judges. First, lifetime appointments, as in the federal system. Second, judicial elections are used in many other states and used here in Vermont to select probate and assistant judges. And third, the judicial retention process. Because we judges can review survey results and comments from attorneys who appear before us, as well as have a discussion with all of you, I believe that the retention process is the best option for selecting judges. Now, I have reviewed all the survey responses and comments submitted about me. I am very grateful for the many good, very good, and excellent assessments submitted, as well as the corresponding comments. But I'm also grateful for the critical assessments and comments made, as I believe that they will be the most fruitful basis for me to improve my skills and job performance going forward. I plan to use those comments and assessments to help me become a better, fairer, and more productive judge. So now I look forward to answering any questions you may have for me. And thank you for this opportunity again to appear before you.
Thank you very much, Judge. At this point, I would just invite our fourth House member has just joined us, I see. And I would ask him if he would introduce himself to the judges present.
Okay.
Will? That's you. If you would introduce yourself.
Sorry, I was a little late getting on. I'm Will Knott. I'm second term representative from Rutland City. I'm serving on the House Judiciary Committee, and this is my second year as part of this group.
Thank you. So, okay, so we will open it up to questions, and I would call again, I'll go in the same rotation. Senator McCormick is just to my left in the screen. Questions from you, Senator McCormick.
Thank you. With so many people on, I just want to make sure, can you hear me?
Yes, I can.
Yes.
Okay, okay. First, I wanted to just do a little bit of a disclaimer in that I note that judges are in the business of enforcing and protecting due process. And in this retention process, you don't get a whole lot of due process. You don't get to confront your, if somebody says something nasty about you. We have anonymous comments and so on. And I apologize for that. This has troubled me for years, although I've never come up with a good alternative. So but I do want to acknowledge that I notice on your comments that they're overwhelmingly good. And it seems crazy with so many good comments to zero in on negative things, but I just want to get them out of the way because we do give judges power, and so I want to give you a chance to address it. You have overwhelmingly positive comments, but some people comment in terms of on judicial management. There were good marks. I'm reading my notes. I'm reading my own notes here. Judicial management, good marks, but some dissents. And that was, I think, on timeliness more than anything, wasn't it? In any case, would you comment? I'd like you to. I want to give you a chance to answer them.
Okay. Well, thank you for the opportunity to comment on that, Representative Senator McCormick. I think that I take to heart those comments, and to some extent, I acknowledge that the process, and I'm going to break down my answer into two parts. The judicial process can take a lot longer than people like. There's one of the main reasons for that is that is the very thing that you first commented on. We have to afford all who appear before us a due process, an opportunity to be heard and to offer both admissible evidence and their legal arguments. And that can take time. I mean, in the environmental process in particular, I think our record is that we had one appeal, or rather a group of appeals together that had 99 different parties. Now that initially appeared to be close to impossible to manage, but we came up with a process by which we asked the parties generally who had similar concerns to elect a representative to speak. And then when they were the first to speak, others could speak as well. But still, that case I'm thinking of took, I believe, 12 days of trial time, and it was spread out over about 3 or 4 months. Now, the other thing about timeliness is then you have to write a decision. And all our trials are bench trials. It's not a jury trial. And the thing about bench trials is the presiding judge must assemble all the factual findings based upon what we determine is the credible evidence, and specifically itemize that, and then announce what the applicable law is, and then apply those facts to the law. We have a goal of issuing decisions as quickly as we possibly can. One of the things that we established in our court to help us with that is we have disposition guidelines, and I believe I had provided you folks with copies of those. And if I didn't, I can. But the guidelines set out a standard of how a case should reasonably be adjudicated. And our goal is to issue a decision, or most of our decisions, no later than 90 days after the matter comes under advisement. Now, we have cases that are decided a lot quicker than that, but there are some that take longer than that. And I fret when that happens, because I can still remember being a attorney representing someone before a court and waiting for that decision to come from the judge. But what we try to do is, I try to do is write that decision so that it's clear, it's understandable, and understandable not only to the parties and not just to the Supreme Court should it go before them, but also to someone who's just picking up that decision later on and trying to understand a similar dispute. But nonetheless, I know that that's something I've got to work on further, and I take it as my primary goal, because I think that's important.
Thank you. I do note that your comments are overwhelmingly positive. The particular negative comment about your timeliness, that was, I think that 3% said that. And meanwhile, you had about 60%, 68% good or better, mostly rating you excellent. So I do want to, and I feel bad even asking, but as I said, I wanted to give you a chance to address it. I think that's all for me right now, Mr. Chairman.
Okay, thank you, Senator McCormick. So we'll switch over to a House member, Representative Shaw. Like to
Thank you, Mr. Chair. I believe that I think Senator McCormick trumped my questions. And thank you for that, Senator McCormick.
Okay. All right. Senator Nick, please.
Hi, Judge Durkin. So I remember when the environmental court started, I was on that House Natural Resources Committee that did the work on that. And at that time, the judge was operating out of her car, had no place to have a courtroom, and was having to find her own space around the state where to hold cases, was having to do all the scheduling at those sites on her own. And it was very good that we were able to get the environmental court really going on a stable footing. And you came in and it's been a nice job that everybody did to really make it work better. So I appreciate you being there all that time. One thing I'm wondering about now, though, is I know I don't know how often this is, and I wonder how often is it that you do other courts' work? In other words, at times the court's been not had a full slate of judges, they maybe now do, but you were being asked to fill in other court situations. And is that still happening?
Yes, thank you for that question, Ms. Nika. It is still happening, but I'm trying to keep a close eye on making sure that my first priority is my responsibilities to the environmental division. I am very honored to have been asked on several occasions to sit in as a specially assigned associate justice on the Supreme Court. Earlier on, it's died down a little bit now. I was handling matters in the civil division in Windham County, a few in Bennington County, some jury trials in Rutland County. That hasn't happened as often anymore. But also, I have of late the shortage of judges over the last several years has been especially hardest in the criminal division and the family divisions. And in discussing that with the clerks of those two divisions, I was asked and I agreed to serve as an assigned judge on a regular basis in the mental health docket. And I continue to do that now. I am not doing any, I haven't done any special assignments in the criminal division for a good 7 or 8 years. I think about the same civil division, maybe 4 or 5 years. And so but the mental health docket has been the greatest need, particularly because I'm down in Brattleboro. So the Windham County docket for mental health is the heaviest because the Brattleboro retreat is down here. But that was a real need because the family division docket had increased so substantially that there was a great need in that division. And when I took on some of the responsibilities, I carry the load every other Friday in the mental health docket in Brattleboro.
Interesting.
Yeah.
And I'm just wondering, with regard to where are you appearing in the environmental court? I know the court itself as a unit all alone doesn't exist. So where do you go? All over?
Well, by statute, we're obligated, now this is pre-pandemic, we are obligated to conduct all hearings and trials in the county where the property lies. That's actually one of the most fun responsibilities of my job, I think. I get to travel all over the beautiful state of Vermont. And particularly in our docket, conducting a site visit, and we usually have done site visits on most all appeals that have gone to trial, it really focuses the mind. I mean, good articulate attorneys and parties can argue something forever. But if you're standing on the side of a highway where a development is going to go, and you're looking at the stakes that someone has put out in the field where this is going to go, and the kindly neighbor who lives up above it is pointing out her house and explaining how she's worried about the lights being visible from her place, that site visit really focuses the mind. Now, site visits aren't evidence, and I make that clear that anything that's important that's said or seen during a site visit, a witness has to appear in the courtroom and recite that on the witness stand before I can rely upon it in rendering a decision. Now, if I may, let me give another aspect of my answer. When the pandemic began, or was realized almost 2 years ago, we followed the directive of the Supreme Court, of course, in Administrative Order 49 and its amendments, and had initially ceased having in-person hearings. We did go to remote hearings, and I've conducted remote hearings and remote trials, and it's actually gone pretty well. The parties have been, and the witnesses have been very accommodating and patient as we work through the exhibits, and it's helped us keep pretty current on our docket. We don't have a lot of cases on our active docket right now that have backed up waiting for trial. Now, as we went through that process, on several complex cases, the parties have jointly come to the court during a status conference and said, Judge, we'd do this in a remote hearing if we could, but we can't. There's 4 or 5 different parties. We each have 1 or more expert witnesses. We have thick reports and thick site maps. So we've begun to schedule those in-person hearings. And that's where we are right now. The environmental court, the main office is in Burlington. But when I first began, the then court administrator was kind enough to come to me and say, look, we want to give you your special chambers closest to your home so you can minimize the amount of traveling that you have to do. So I have the chambers and office in the Newfane courthouse in the Superior Court of Newfane, and I truly enjoy working out of that court.
Nice courthouse.
Oh, well, I'm biased. I think it's the most beautiful courthouse in the whole state. And actually I've presided over a trial now, just because I'm old. I presided over a trial in every courthouse in the state of Vermont so far.
Well, thank you. That's all for me.
Okay, thank you, Senator Nitka. So back to a House member, Representative Colbert.
Thanks. That's a really cool record to have presided over a trial in every courthouse in the state. I really like that. Thanks for sharing that with us. I'm curious, just reading through your materials, it's clear that you have a really long history with Act 250, dating back to your involvement with the District Commission and then being really in a really important way as the additional judge helping to kind of implement that expansion of the court and reform of that environmental court. I'm wondering, and I know you recently testified, I think in the legislature. I haven't had a chance to listen to it on Act 250, the ongoing Act 250 reform. So how do you find that balance between kind of the neutrality you need to, as a judge on that, and just kind of thoughts, feelings you might have about the policy itself, which I think you probably worked with for a long time. And you have worked with for a long time.
Well, thank you for that question. That's a fascinating one. And it makes me think first that the interesting thing, one of the hardest things to do as a new judge, given that new judges usually have 10 or more, and I had nearly 20 years of experience as being a legal advocate. One of the hardest things is to do away with that advocacy trait. You want to hear the evidence, and you want to keep an open mind till all the evidence is in. And that can be hard, particularly when you were advocating for one side or the other up until that process. But it was actually when I was chair of the district commission that I learned how important it is to keep that open mind and to not bring whatever thoughts you may have about policy into the courtroom. I remember a particularly contentious hearing involving a large ski area resort development, and it went on for many days, and people had strong opinions. And I started to wane, and because of all the witnesses that had come forward, and then towards the end of the hearing, this older couple, and I later learned he was a retired engineer, she might have been a retired engineer too, said, we just have a few things we want to say. And so we swore him in. First the husband and then the wife testified. And I can't remember the particulars of their testimony, but what I can remember is that they succinctly testified to this crystal jewel of an analysis of the facts and the concerns that the community had about this expansion of development. And that I still remember to this day, because I remember it reminds me to say, look, You got to wait till all the evidence is in. That little old lady sitting in the back of the courtroom that raises her hand just as you're about to close out the hearing, she might have the most succinct, best comments and testimony that you can receive. So I value that very much, and I think that's how I can separate it. And then over the years, I've been doing this for 17 years, and I think I've testified before legislative committees most of the years. Act 250 has been a hot topic in the Vermont legislature, as it should be. It's been a good exercise to make sure I don't wander into your policy arguments. I don't want to intrude on that, but I want to provide you with some facts of how the court operates. And most recently, I did testify before House Natural Resources on a bill that's pending concerning Act 250.
Thank you for that. I appreciate it.
Yeah.
Nope, I'm all set.
Okay, all right, thank you.
Answering my question. I'll stop there.
So Senator Benning is next to Senator Nitka. So Joe, take it away.
Thank you, Mr. Chair. Judge Durkin, greetings again. I think we've seen each other a couple of times here, and
Yes.
you were 2 years behind me at the law school, so I think we probably ran into each other when we were both a lot younger.
Every once in a while, yes.
I am very jealous that you are practicing or presiding in the Newfane courthouse. It is the only courthouse in the state I have not been in, and it wasn't for lack of trying. This past summer, my wife and I stopped and spent the night at the Four Columns Inn, and
Oh,
we
gee.
specifically went there at a time when I knew the courthouse was going to be open. And I walked in the front door, and the guard said I was not allowed in the building.
Oh, dear.
And I tried to give him the "I'm the chair of Senate institutions, da-da-da-da-da" routine, and I'm an attorney for 38 years. He had none of it and wouldn't let me in the door.
Oh, golly.
So next time I try, can I use your name as a suggested contact person and see if I can't get in?
Please tell Scott, who's the fellow at the front door, that I invited you to be there and that you're there in response to that invitation.
I appreciate that.
He takes his job very seriously.
He obviously does. And you should be very proud of that, because he did very well keeping me out the door.
Well, it's funny that you mentioned that. I'll just tell you a quick story, because it used to be that there was no security at the front door in Newfane. And there's two quick stories. Back when Justice Carroll was a trial judge, she was upstairs in the chambers upstairs, and someone came wandering in simply because they needed directions. And so they came just waltzing into her office to say, "Can you just tell me how to get to Manchester?" or something like that. And then it used to be, again, when there was no security at the front door, my office is just down that hallway where my chambers is on the first floor. And particularly during foliage time, I would forever get people coming in, wondering if I could show them around the courthouse, wondering if I could give them directions. And I just enjoyed that, so I just played along with it.
We're probably dating ourselves, Judge, because I remember the Guildhall Courthouse being a place where you could walk in the door and the clerk would ask you what you'd like in your coffee.
That's right. That's right.
But back to business. I was cruising right through your application answers, and I have to say, I was cruising so fast that it was like I was just completely bored. You have nothing against you at all anywhere. Perfect record as far as I was concerned. And then, of course, my eyes have to glue onto the one thing that's probably got you still scratching your head, and that is in the bias section. There is a gentleman, or I'm assuming it's a gentleman, who is commenting about out-of-state attorneys who may be of a particular faith apparently having a concern about you being biased against them.
Mhm.
And you don't need to say who this person is, but I would like to know, yes or no, do you know who this person is? and then I'll follow up with another question.
Okay. I do not. And like you anticipated my response. I was scratching my head. I can't fathom how that comment was made.
Okay, it is unfortunate because I see it as a potential blemish on what is otherwise a spotless set of responses. But evidently somebody was concerned enough to register a statement like that. So I have to presume they themselves had some concern that gave them the motivation to write that statement. I'm curious, in your courthouse, if you ever run into situations where there is conflict like that, do you take an opportunity to invite someone into chambers to have a conversation to try to clear the air?
Well, that's an intriguing question because I can only remember one, maybe two instances where I invited someone into chambers alone. And I made clear before we left the court room that I wanted to talk with this individual privately, and it had nothing to do with the case that was pending. And there were two instances now that I remember it. One was a younger attorney, and this is going back, Joe, maybe 12 years or so. In fact, we were still in the Berlin building where we used to have our office and courtroom. And I simply said to him, I perceive that you're frustrated. And I think he was very nervous about how to put in evidence. He suffered from that thing that young attorneys always suffer from. I suffered from when they're grilling their witness, they're asking leading questions. And a skilled attorney on the other side will jump up and object to steal their rhythm and such, and also to object. And so I said, there's some good, capable, I remember telling them there's some good, capable attorneys in this state, including a few in your firm that could help you understand this. And we had a good conversation. As I recall, he thanked me after, and we've since had cordial relations, I would call them. Since then, said hello to each other with a smile and such. So the only other time I called someone in chambers actually was when Judge Wright announced her retirement, and they were vetting people to fill her spot. And there was this younger attorney appearing before me in a case, or younger than me. And I asked if I could speak with him at the end of the day. And again, I made clear to the other parties that I'm not talking about the case. And it was Tom Walsh. And I said, Tom, I've always appreciated how well prepared and how thorough your presentations are. I don't know if you're thinking of applying for this position, but if you are, I wanted to offer my support because I think you'd be a great addition to the court. And
I appreciate that. Sorry, I had to be the flag that noticed that particular comment, but frankly, I've been on this committee for 10 years now, and that was one of the oddest comments I ever came across. But I appreciate the fact that your door is open.
Absolutely. Absolutely. Thank you.
That's all I have, Mr. Chair.
Okay, thank you, Senator Benning. We'll go to Representative Knopf. Do you have some questions for the judge?
Thank you, and thank you too, Senator Benning, because he asked that question better than I would have framed it, and I did notice that as well. And actually, that was it for like questions specific to having reviewed your material, Judge. I did have one question that I was going to ask everyone this year, and this is only my second year on this group, and I'm still figuring out things as I go, and I'm also trying to figure out processes. And one thing that we heard a lot last year, and I suspect we'll hear a lot of it again this year, is the isolation, things are remote and whatnot. And I wanted to ask every judge that we have the opportunity to speak to this year, how active, how as far as keeping up on things, are there listservs, are there Facebook groups, are there interactions that you are doing that could be an exchange of ideas that might have occurred in person in a building 3-4 years ago that aren't happening that way now, or is a lot of discussion just by necessity in your world stagnant until we are past COVID restrictions and the buildings are actually full and processing again?
Thank you for that question. It's an important one. I don't do social media. I just, I don't have a Facebook account or Twitter or whatever else is out there. Frankly, I decided that early on, not just because of the ethical challenges that can bring sometime, but also, my old school way of thinking is I don't need another mailbox to check on a regular basis. I got too much going on already. Your question is an important one, particularly since the additional isolation that the pandemic has brought. Thank goodness for the ability to have video conferences. We do in part to the isolation that we sometimes suffer, we judges. We have a regular call of all trial judges are invited to. It's a team on Microsoft Teams once a week to just air out certain concerns and issues, see if there's other things that other judges are challenging with. And I guess the one thing that I'd want to comment on too that you may not be aware of is the camaraderie that is the judicial bench. There's all of 35 trial judges when we're at full force. And you go to most cities and that's still regarded as a small sized law firm, but I'll never forget Judge Katz coming to me when I first got appointed and saying to me, "Tom, welcome." I had done a few trials in front of him when I was a lawyer. He said, if you have any questions that come up that you think I can help with, call me, email me. If you call and the clerks tell you that I'm on the bench, ask them to interrupt me and get me off the bench because I want to respond to you as soon as I can. And that was incredible. And I had several other judges offer that. I've offered it to most judges that have come after me because there's a camaraderie there, a common goal of addressing the legal challenges that are presented to us in the most credible, authentic way. And I'm honored to serve with all the other trial judges that are on the bench with me now. One last thought, if I may. I've often daydreamed of, well, geez, if I hadn't become a judge, and I'm so very grateful that I have, but if I hadn't, and I had the ability to select the partners that I would work with, I dare say that I would select these 35 people to be partners in my law firm with me.
Great, thank you. That's all I have. That was very insightful, and just a little editorial. Not being on social media was probably a very wise choice.
Yeah, thank you. Senator Hardy. The mic is yours.
Thank you, Mr. Chair. Good evening, Judge Durkin. I have a couple questions for you. First of all, in skimming through your CV, I couldn't help but notice that you were on the Vermont Judiciary Flu Committee, and from 2007 to 2016, which was supposed to be a pandemic planning committee. And you acknowledged that you had no idea about the pandemic was going to happen while you were planning. But I'm curious because the Vermont Judiciary has been criticized for its reaction to the COVID pandemic and the way that you've gone about your business, or in many cases not gone about your business. And just last month, there was a big article in 7 days. I pulled it up right here on my screen. Vermont's judiciary is a national example of a COVID-19 disabled system. And you yourself said that you've been all over the state at every single courthouse in the state. So you should be very familiar with the physical layout of those courthouses. And I'm wondering, given that you were on this planning committee for so many years, certainly the issues that we were facing, while you couldn't have known them all, some of them certainly had come up. So why was the judiciary so unprepared for COVID, and why do you continue to be so unprepared for it?
Well, thank you for that question. I mean, all I can reference in my answer to you is how our court operates, and to some extent the family division in Brattleboro, because I'm covering the mental health docket there. I don't agree with the assessment, if there is one out there, that the judiciary was wholly unprepared. I remember working on that committee. I worked with now retired Judge Amy Davenport and now retired Judge Matthew Katz. Now, not only did we not have a full appreciation then, or we didn't have a crystal ball to tell us what the pandemic may be, we didn't have a crystal ball on what our technology capabilities would be 10 years later. We've gone through a wholesale evolution, perhaps even revolution, of our technologies. I guess, well, I would say this: the trial judges, many of the trial judges that I've spoken with, have expressed similar frustrations about the current circumstances for in-person hearings and the like. I think I've worked closely with the past court administrator and with the current acting court administrator. I would never want that job. There is a challenge there that you can't imagine. You've got, there's few courthouses that are similar to one another. Everyone's different. The county courthouses as well as the state court buildings. You've got groups of people, sometimes large groups of people, that you have to interact with and protect. So I wouldn't want that job. All I can talk about is how we've addressed the needs of the litigants and staff in the environmental division. And I think we've been able to, because of the challenges, but also opportunities that have come with the Odyssey case management system, we've been able to keep up with our docket. I don't believe, I'm not aware of a backlog at all in our division. Now, I am aware through others of a backlog in the criminal context because of jury trials, but they have been doing jury trials now, and in the family division, because this pandemic has not just brought about medical challenges to people, it's brought about emotional and mental health challenges to people, and those sometimes people can't fully resolve those issues themselves, and they turn to the courts. And I know the docket in the family courts has a challenge, but it's not just because of a backlog because of AO 49. It's because of the explosion in the filings as well. So I'd caution you, just say, look at the filings as well. I did see that 7 Days article, and I read it, and I was disheartened by it. But again, all I can talk about is what I've experienced firsthand in our docket.
Well, it's good to know that the environmental docket is not backlogged. Last year, we had Judge Grierson up for retention before he retired. His last thing was to get retained and then leave. So this is probably Judge Zone's job now, but we talked to Judge Grierson about the fact that the court was still not functioning very well a year ago, and still a year later, there are still some problems. And so maybe this is a question for some of the other judges, but I have heard from constituents and others the frustration with the backlog and the frustration with the way that the courts are not moving as quickly as they need to be. And I just hope that if you're on a flu committee again, you'll have learned a little bit. We all have certainly learned more than we anticipated about what we need to do for our facilities and our processes, et cetera. My other question is a note that you made in your letter to us. And your quote was, "I would welcome the legislature's assistance in improving public education about the rights and responsibilities of participants in court proceedings." And I'm wondering, since you asked for our assistance, what specifically do you think we could do that would be helpful in that manner?
Well, I guess, and of course, this will come from my bias from serving on the bench. That most people out there don't know a whole lot about what goes on in a courtroom. Except for what they, God forbid, they've learned from some half-hour television show. And most people, including many litigants that have come before me in the environmental division, have never even been in a courtroom. Now, when they tell me that, I often say to them, well, that's a good thing that you haven't had need to come to a courtroom. But I serve as the judiciary's representative to the Vermont Bar Association Board of Managers, and the VBA, and with Terry Corson's great help, have tried to, over many years, do a good job in educating the public, educating secondary school students and even middle school students. And I think that has to be reinforced even more, because when people come into a courtroom expecting that the court's going to answer all their questions, there needs to be an appreciation of the limitations of what we can address for people, and the manner in which our process is going to happen. I mean, I remember being a chair of the Act 250 District Commission, and that was much less formal than a courtroom. We were sitting on the other side of a folding chair in metal fold-up chairs and having a discussion. Now, we swore people in and we took evidence and we rendered decisions, but there was more of an interplay, and courts aren't set up for that, for a good reason. I don't want to know all the background information. I want to know just the relevant facts, and I'm going to rule based on those facts. But I wish there was some way, and I don't have suggestions for you to answer my own question, but I wish there was some way that the legislature and our school system could train students to be better prepared as civic individuals when they reach adulthood.
Well, you're speaking to the choir with Senator McCormick there. He's probably so excited that you said that. Well, if you have any specific suggestions, please let me know. I mean, and I do mean that, like, even in 6 months, if you come up with an idea, please reach out to me. But overall, everybody has sung your praises, and you have such a great record, but I did want to make sure you had to answer some hard questions too. And I did want to, on a political note, just thank you for your decision in the Slate Ridge case, by the way. So thank you for being here tonight. You're welcome to comment on that if you want, but I appreciated your decision.
It was intriguing to me that the relevant facts related to zoning violations. They had nothing to do with what that gentleman may have wanted to talk about.
Exactly. Well, I thought it was, I can't think of the right word, but good justice, I guess. Thank you.
Welcome.
Thank you, Senator Hardy. So I just wanted to thank you for coming in, Judge Durkin, and being very forthright with our committee. I have a few comments. I had picked up on from some of your writing about a comment that you made. The E-Court has wide and sweeping implications. And certainly after reading the Valley v. Costco decision, which went on for quite a few pages, and it was a case that I kind of followed, I would have to suggest that the degree of involvement and and twists and turns that some of these cases have taken, and particularly that one, and your ability to follow it and to make really sound decisions and to deal with litigants that just kept coming forward on it. Of course, that's what they're paid to do, but it was just a really a good thing to read, and a good thing to see that the effort that you put into that case, because it was a pretty far-reaching case as far as things go in the state of Vermont.
Thank you.
And I think I agree with everyone else. The remarks and comments on your judicial demeanor were excellent, and I'm happy to see you here tonight. And thank you for being here. And I think that's about all I have to say. And it's been a pleasure meeting you. And one actual question. You say you've been in every courthouse in the state. I don't doubt it, but were you in the Guildhall Courthouse before or after the renovations?
Oh, golly. It must have been before, because I would hope that the renovations included taking out the open air toilet that was in the judge's chamber in back.
That's what I was referring to.
Yeah.
Absolutely
There
right. So
was a curtain that
renovation.
you had to pull out around you. Yes.
Yeah. Okay, very good. Well, thank you, Judge Durkin. Yes, Senator Mitka.
I just was wondering if I could ask one more question of Judge Durkin.
Sure.
I'm just wondering, Judge Durkin, with regard to, there's a lot of needs right now for children who have mental health problems, teens and younger children. And in the mental health court, are you finding resources for them, or how's that going?
I can't say that all the needs have resources to address them. And, we're just learning the tremendous challenges that people face because of mental health issues. Now, in a case in particular that goes back about 2 years ago, I came into a case after another judge had specifically directed the state to find a spot in a mental health facility for this individual that had just lingered in an emergency room for, at that point, like 4 or 5 days. And I came to the case the following week. The person was still in the emergency room, not getting any treatment at all. And I took it upon myself to say to the Assistant Attorney General, who I think was trying to do a good job, that I considered that to be in contempt of the prior order of the court, and that they really needed to do something immediately. And I think there was something already in the works, so something was cured immediately. But thank God for the Brattleboro Retreat and all the facilities and doctors that they have there. But we need more options and more varied options, because people have more varied needs than what they did 50 or even 100 years ago when the retreat was first created.
Thank you.
That's it, Alice? Yep.
Yes.
You okay? Thank you. Okay, thank you once again, Judge Durkin. And
Thank you very much.
and you're welcome to stay on board here while we
I
speak with.
I think I will, but I'm going to stop my video and mute. But thank you again
Okay.
so very much, folks.
Thank you.
Thank you.
Thank you.
And Judge Finster, welcome.
Thank you.
I am pronouncing your name correctly. Finster it is?
Fenster, yes.
Yes, okay, very good. So you have an opening some opening comments that you'd like to make?
Just briefly, I would like to thank you all for this opportunity to speak with you, and to give you and to give me an opportunity to talk about my experience on the bench and why why I'm seeking another term, to be retained for another term. As my application notes that most of my career has been dedicated or had been dedicated to public service. I was a deputy state's attorney for quite a while, and then I was in private practice for a time, and then I was state's attorney for a time, and there came an opportunity to I was given the opportunity, and I was appointed to the bench, and it was one of the proudest moments of my life, and I have always been humbled by that opportunity, and I wake up every day thankful that I have had that opportunity, and I'm seeking to continue to serve the people of the state of Vermont in this capacity. It is new. This is my first time through the retention process. I was appointed in 2000, at the very end of 2016, and really didn't begin to preside until 2017. I was originally appointed, well, not originally appointed, but I was originally assigned to a rotation of a number of different courts. And I was moving around a lot, filling in where assistance was needed. And then my first rotation, my first full rotation was in Chittenden, where I was doing a combination of criminal and family, mostly criminal. Then I was given a split where I was in Chittenden and Addison 1 day a week. And then most recently, I have been in the Rutland Criminal Division for the past 2 full rotations. I have not had a chance to preside in all of the courthouses in Vermont. In fact, I've not had, as you might imagine, I've not had a chance to preside in very many, given my relative inexperience. I can tell you that this has been, I have grown so much in my years as a judge from the time I began until now. I have learned so much. I have to echo what Judge Durkin talked about earlier in terms of our colleagues, the generosity of time and knowledge and guidance of our colleagues. I cannot overstate it. It's a wonderful resource to have, and I am unbelievably proud to be able to call the other individuals on the bench my colleagues. I don't have more to say than that at this time, but I just want to thank you for your opportunity. I've learned a lot. Oh, I'm sorry. I did look at the questionnaires and I worked through them. There was one concern that I noted about some timeliness of decisions by one of the respondents. That is an issue. When I was first appointed, especially in the family division, I identified that I was taking longer than I would have liked in terms of amassing all of the facts and working through all of the facts in a family court case. They're difficult. Taking an entire family's incomplete financial as well as social circumstances, aggregating it together, digesting it, trying to find out what it means, what it means to them, what it means under the statute with the factors that the court has to consider. It was taking me longer than I was happy with, and I took steps to remedy that. And I believe that I have been issuing my decisions much quicker. So that is definitely something I noticed as well. Like Judge Durkin mentioned, these questionnaires are an opportunity for reflection and growth. And so I'm certainly glad for the responses that I've gotten. I thought they were mostly positive, but I certainly, look at them with a critical eye, because I feel that I can always do better. That the people of the state of Vermont deserve me to always be looking to do better, and that is how I take my job. That is how I take this position and how I look at this position. So thank you for your time. I don't know if you have any question, or I'm sure you have questions rather, but that is all I have for my introductory remarks.
Great. Thank you, Judge. So we'll reverse order and we'll start with Representative Knott.
Thank you. First time back at my home computer and I'm having trouble finding the mouse to mute and unmute. Thank you, Judge. Thank you. I did have, so just one particular question that building off of what you had said, because you did mention seeing the need to, or recognizing the need to be a little more timely in your decisions. Could you just give some, I don't want to take up too much of your time, but just some specific example of like what you recognized and sort of how you addressed it?
Certainly. Early on there, I was working, getting, first of all, a lot of the facts in mostly family court cases, aggregating all of the financial data of the parties, the social aspects of the other factors, the parental rights and responsibilities issues. One of the things I did, honestly, was I started to use an Excel spreadsheet in every divorce involving financials that I had, and I would start to input all of the assets as quickly as I could into the spreadsheet, so that when the parties would start talking about different assets and moving different assets and one party wanting one asset versus another asset, I had it all in an Excel spreadsheet that was able to sort of give me a very quick picture of how moving any particular asset or any particular income stream would look. It also allowed me to input income of the parties into the same spreadsheet, and to look at what different percentages would look like. If I was to give a certain percentage in terms of an award versus a different percentage of an award, what does that look like? What does that look like in terms of a monthly number? What does that look like in terms of an annual number? It did take me some time to develop that, so that I would have this handy tool, that I needed in order to find a way to take a look at the whole picture in a way that allowed me to understand what was going on with this family. What would the impact be if I awarded a particular asset one to one or the other, or divided the asset, or offset some asset distribution with some type of cash award, if there was anything available. And also, what would different distributions look like under the guidelines that were, there are the guidelines that are in the statute as well. And it was very helpful for me to be able to see what each percent of, there's a range and different percentages, what each percent looked like in terms of an actual number, in terms of what people are going to be living with, or being asked to live without. And so that tool was a significant, it certainly made a big difference in my ability to quickly assess or more rapidly assess the assets in the case. The other thing that I did was I tried to make a practice of at least drafting out the facts as quickly as I could, hopefully, before, even if there was more days of testimony that were coming, even if there was no opportunity for me to sit down and actually start crafting the opinion, I would try to get out a group of a set of the facts from the testimony that I had heard, subject to potential revision if there was more evidence. But at least I would have some working group of some draft that I could begin to work from. And then, so those were the two things that I did primarily to work on that. The other thing I did was I developed a spreadsheet that I now use for all of my under advisement cases, which tells me how many days they've been out and when they're due and things like that. So.
Right. Thank you. No, that was very informative. And is someone who is personally at least mildly obsessed with Excel spreadsheets. It warms my heart. My only other question for you is, well, if you were listening to the last round, spoilers, because I do want to ask this of every judge. You know, we know that we're all in isolation the last few years. You know, we know that communication is difficult. So I am curious, as far as keeping abreast of things and having a free flow of ideas and whatnot, you know, are you Facebook, any listservs, any communal organizations like that that are, you know, keeping you plugged into the process as we slog our way through COVID restrictions? So,
like Judge Durkin, I'm not on Facebook, but I do keep abreast. I mean, what Judge Durkin mentioned, we do have a trial call. It used to, at one point it was weekly. I think it's maybe weekly again, but it's at least every other week. During the pandemic, and I don't know if this is during the pandemic, when the lockdown first started, I was having a weekly bench bar with the county bar. Just every once a week, we would get on to either WebEx or Teams. I believe it might have been Teams at the time. And we would have a bench bar just to discuss what was going on. Sometimes nothing had changed and we would just check in with each other. Other times we were able to give out updates to the information about what was changing with the courts and what we were able to do. The other thing is, you know, because I've been sitting in the criminal division, I have been coming into court sometimes, at least throughout the pandemic, at least some of the time. I do preside remotely. There are opportunities for that, but I do go into the courthouse and there are other judges that I still get to see from time to time. And as Judge Durkin mentioned, our colleagues are always available. They're, especially now, to some extent, when I say now, some of these tools existed before the pandemic, but everyone's become so much more comfortable with them. You know, if I have a question, I'll reach out to a colleague through Teams. We'll have a conversation about it. I might reach out to another colleague. Sometimes we'll get a group of us together to discuss something. So it's been. I speaking for myself, I have missed having in-person contact with my colleagues. That is, I certainly don't want to make it seem like this has been a complete replacement, but we have had, I think, even amongst the judiciary, interactions with each other. We've maintained ties with each other, and I believe that there's a pretty robust system of discussions with each other in terms of, like you said, the sort of updates and what's been going on and what's happening with the law.
All right, thank you very much. I'm all set.
Thank you. Thank you.
Thank you. Senator Hardy, you have some questions for the judge.
Thank you, Mr. Chair. Thank you, Judge Fenster, for being here, and also one of my constituents. So we have kids in the same school. I wanted to ask you, I did not see many comments on your, so I'm not sure if I'm missing a page of your report, but you had almost no commenters, which was a little sad. I'm sorry that you didn't get more feedback. And I didn't see the comment about you taking too long. So
it was not so much a comment, but one person voted fair.
Oh, it was in the rankings. That's okay. Yeah. That's fine. But there was one comment about, I think it was something like, even though he used to be a prosecutor, he's not biased. And so my question is more general than that. As a new judge who did used to be a prosecutor, how do you deal with potential implicit bias? Or we all have implicit biases. So how do you address implicit biases in your work and ensure that you're not being biased, whether because you used to be a prosecutor or just because you're a human being? So how do you overcome biases?
I mean, I think it's something that we all wrestle with. And so what I do is I try always to take a moment. to take that extra moment and to check myself and to have something of an internal dialogue with myself about, did I check with this side? I did. Did I check with that side? Did I give this side time? Did I give the other side an opportunity as well? Just trying to slow things down, keep an internal dialogue, and try to check in with myself as if there were another person there, almost sort of just making sure, because in the moment, you're doing what you're doing and you're working and you're concentrating on what's in front of you. And I do my best to try and keep a little portion of what I'm thinking of is to not just what am I doing, how am I getting to what I need to get done in the case, but how am I doing that? How am I, as the judge, presenting that? How are the litigants and the lawyers who I'm in front of, how are they viewing that? Because we're all humans and we all are in the moment and we're doing our work, and we have deadlines and we have time constraints, and so I do try to just keep some portion of what I'm doing, paying attention to how I'm doing it.
That's great. So what is your answer to the criticism and the concern about the courts not being up and running adequately given the COVID pandemic?
So I think I can't answer. I don't know that I can answer that broadly. I can only tell you what I've observed. I mean, one of the concern, so having a jury trial, for example, is inherently a congregate event. And so to draw a jury, you're bringing in, jurors, you're bringing in 60, 80 jurors, and you're, in traditional times, you're keeping them in relatively close quarters. You've got all of the lawyers that go along with that. You have all of the clients that go along with that. You have other interested parties who may be interested in the litigation, who want to be there. You have the court staff, and inherent in the process of a jury trial, for example, is bringing together all of these people and requiring them to speak. And one of the things that we learned, in the course of learning about the transmission of the virus was that, one of the most risky behaviors was to bring a large group of people into an enclosed space and having them all speak. And so, there was a lot of learning that needed to happen in order of how do we do that in a way that keeps all of the people that we're not just asking to come to court, we're requiring them to come to court. I mean, the people who come to court, the jurors are summoned to court. And, we do provide for some latitude in terms of people who have concerns, and we can excuse people, but people are summoned to court. It's not optional, and the litigants are required to come to court. And so, it was a challenge, I think. And again, I can't answer for the whole of the judiciary, but it was a challenge as to how we could do what is inherently a congregate event, which is at least a jury trial is. How do we do that in a way that keeps everyone safe? I will say that, in Rutland, at least, I can't speak to, we've drawn 10 juries over these past months. We traditionally could have drawn some more than that. But again, we're reducing the number of people we're bringing in. We're separating the number of people we're bringing in. We're keeping masks on the people that we're bringing in. And as far as I'm aware, we have not had any, and again, I would defer to Judge Zone, who has sort of the broader picture, but as far as I know, we've not had, I'm not aware of any transmissions that have occurred as a result of people attending at least the jury trial, maybe any of the court proceedings. But and different buildings, had different air handling capacities. Some of the older courthouses had different air handling capacities. And so I don't know that I have I don't know if that's an answer. I can tell you that that's what I've observed. And like I said, I can tell you that through in Rutland, at least, we had been consistently open. We had been holding hearings, some in person, some a lot remote. We were definitely bringing in many, many fewer people than we had been in the past. But at least in Rutland, which is the only court that I sat in while the pandemic was going on, criminal court cases were moving forward.
So
sometimes we had to delay things, though. I will say that.
Yeah. So is your docket, are you more or less caught up on it, or are you still, do you still have a long list?
So Rutland had a long list before the pandemic began. And so we still have a long list, but which is, one of the things that when I first got to Rutland before the pandemic started was one of my goals was to try to reduce the long list that we had before the pandemic started. And then the pandemic started. So the list didn't get much better. Although I will say fewer cases came in during the pandemic than had, and I say that, but it's really anecdotal. My impression is that fewer cases were coming in during the pandemic for various reasons that I don't necessarily know why. The police at one time I think may have been interacting with people less frequently. People were not leaving their houses, but we had fewer cases for a time. The number of cases has risen somewhat. And so we do have a backlog, but like I said, we had one when we started. So not that I'm satisfied with that being there, but we're doing the best that we can to move through it, again, while still making sure that everyone stays safe in the process.
Okay, fair enough. Just one last thing, which is more of a comment. The case that you submitted for us to read, the State v. Stevens, the bail case, it's fascinating to read as a legislator because the whole thing hinged on these two words, the difference of upon and by. And if you all haven't read it, I encourage you to read it because it should make us, it's a cautionary tale for legislators not being careful with their language. Because my first thought was, well, if upon only appears 4 times, was it maybe just a different committee or different year or different drafting attorney who used upon, or was it really intentional? Because one of my committees had a very long conversation the other day about may, shall, and should. Anyway, I thought it was fascinating. And, I think we should have more opportunities as judges and legislators to have those kinds of conversations. So thanks for submitting that case for us to read.
Thank you, Senator Hardy. Representative Coburn.
Oh, thanks. I have a question that I think builds a little bit on Senator Hardy's first question, which is just, well, I will say I also found your bail case fascinating. Someone who's really interested in bail reform, and it's something I'll read more than once. But my question is about, by my estimation, if I did my math right, I think you, between your time as a deputy state's attorney in Bennington and a state's attorney in Addison, spent almost 20 years representing the state in one way or another as a prosecutor. And so I'm really wondering what this transition has been like from that role to the role of judge. And I just was noting as you were speaking to us too, that at some point you've been presided, at least briefly, over the county where you not that long ago been a state's attorney. And so how do you make that transition, and what has been, if anything, has been challenging about it? Because I would imagine it's just a very, very different mindset. Maybe you don't feel it is, but I'm just so curious about it.
So, well, let me say 2 things. One of which is when I was sitting in Addison, at least in the beginning, I was only in family court. So it was only relief from abuse cases and domestic cases. I wasn't sitting on any of the cases involving my old office, at least not at first. At some point, it's been now 5 years, I do see cases that occasionally come from my old office. But one of the things that, one of the aspects of being a prosecutor that I enjoyed when I was a prosecutor was that being a prosecutor isn't about winning at all costs. Even being a prosecutor is about doing justice. And so as a prosecutor, if there was a reason to not bring a case, if justice was to not bring a case, then that was the just result, and you didn't have to bring the case. If there was some flaw in the evidence, a search was not done properly, you had that opportunity, you had that flexibility. It was part of your job to make sure that if you didn't think that that was a good search, that you didn't proceed with that evidence. So it's definitely a different mindset. I'm not saying it's not a different mindset, but one of the things that I always appreciated about being a prosecutor was the fact that as a prosecutor job was to do justice, you represented the state, but you did not have a client. You did not have to always advance the most, if you didn't have a client who might ask you to do something more than you thought was appropriate under the circumstances. So that was one of the things I appreciated is when I was a prosecutor. And the transition, I think all judges have to make that transition because we all come from some area of advocacy, and whether it's advocacy on behalf of the state or advocacy on behalf of private clients. And I did represent private criminal defense clients when I was in private practice. And I don't know that it was quite 20 years. It's close. I would have to sit down and do it. But for 4.5 or so, for a little more than 4, I was in private practice, and part of that was representation of criminal defendants. And so I did have the opportunity to see both sides of the issue and to work on both sides of the issue. And so becoming a judge, that helped in a lot of ways to inform my not view as a judge necessarily, but it helped to inform what to know to expect when you're sitting as a judge. But I think all the judges have to take that, have to make that transition from being the advocate to being the one who makes the decision about the case. But like I said, one of the things about being a state's attorney was there were times when part of my job as state's attorney was deciding not to do something, or deciding that the evidence wasn't sufficient in a case, and telling someone, sometimes it was law enforcement, sometimes it was someone who was making a complaint, that there either wasn't enough evidence or it didn't meet the statute. So again, I'm not suggesting that there isn't a transition. There certainly was. But it was a transition that was something that I think, like I said, we all as judges have to negotiate when we are appointed to the bench.
Yeah, absolutely. And I hope it didn't sound like I was implying,
No.
that there was anything wrong with moving from that prosecutorial role into a judicial one. It just seems like whatever. Very similar to my question to the previous judge. I find that shift really fascinating, interesting, and I like how you described it as a shift from kind of one advocacy role into this. And I just would imagine there's a lot that's really interesting about that, and a lot that's really challenging about it too along the way, especially if you're first making that shift. Thanks. Thank you.
Thank you. And I apologize if anyone thinks I'm looking down. There's just a bigger version of the picture for the representatives. Because if I look at I have 2 monitors, and if I look at the one that's up here, it's a very, very small picture, and I can't actually see you individually. So I look down here. I'm not looking away. I apologize. That's one of the things, and I apologize for this, but one of the things I miss about in-person hearings, and I was in court today, and so I did a couple of hearings, and I had the opportunity to talk to people while looking them in the eye, which is something that I really miss, because here, I mean, I'm trying to see your reactions and to make a connection, but to look at you, that's where the camera is, but you're actually the image of you is down here. And so, and this goes back to the other issue I'd raised earlier about that inner monologue. I mean, that is part of that inner monologue, is I'm paying attention to the fact that to you, it may look like I'm not paying attention because I'm looking away, when in fact, I'm actually looking at you. And it's a challenge. It's a challenge to do that in such a way where the litigant, or in this case, the person you're speaking to, that they realize that you're making contact, and to try to have a relationship. This remote proceedings are they've been very good for what we've had to do, but I do miss in-person proceedings as well. So I apologize for the digression.
It's understood, Judge. I spent a week communicating as you are right now with my committee in this room, so I can totally appreciate what you're saying. It's very disorienting, and I'm sorry for that for tonight, but we thought that it would be easiest for the three of us to be in this room.
No, it's entirely all right. I just wanted to make sure that it wasn't it wasn't misunderstood what I was doing. That I had another screen over here.
Mr. Chairman, may I jump in for a moment?
Yes, certainly.
May I jump in? Thank you. Speaking of in-person versus Zoom, when we first started on Zoom, there was a colleague who I was convinced was flirting with me, until I realized she was looking at herself.
All right, thank you. So Senator Benning, I think that you would be next in line.
So good evening, Judge. I don't think I'm going to spend much time with you, frankly. I was listening to earlier comments, and when you said you looked at the answers in this questionnaire as an opportunity for growth, I immediately thought you must not have had a lot of growing, because this is absolutely devoid of any comments. And you got 100% ratings for reappointment from non-attorneys and attorneys alike. And that is an extremely rare thing. I've been on this committee 10 years. So I'm not going to suggest you stop looking for opportunities to grow. Sorry, it's getting late. But frankly, from my perspective, there's not a whole lot of reason to keep you up much later. You've done a fine job, and I can only offer, I hope you keep up the good work.
Thank you.
Thanks.
That's very kind. Thank you.
Thank you, Senator Benning. Representative Shaw.
Thank you, Mr. Chair. So, Judge Fenster, you're a newer person on the bench, and in the past, we've heard some of the folks that have not served as long as Judge Durkin say that being on the bench can be very lonely. I have had to remove myself from some of my community interactions, and that's very difficult for them and possibly you to cope with. So we heard Representative Knott talk about keeping plugged in to the bench, and I think there's something more to the being on the bench than being plugged into the bench at this time. So how do you unplug? How do you keep yourself refreshed? How do you keep yourself balanced between the job and your family and your responsibilities as a parent? Just how do you feel about that?
It's a challenge. I think it's a challenge for a lot of people to balance work and family. I can tell you that I have a wonderful wife who is incredibly supportive, and I love her dearly. I have two wonderful children, and they actually. So my daughter actually moved out to Denver and is a nurse out in Denver, and so I'm looking forward to going to see her as soon as it's available. And my son He lives at home, and he has graduated, but he still lives at home. So I spend time with them. I try to make sure that I spend time with them, and I try to go hiking. I have taken up a hobby of trying to, I don't want to say be a woodworker because that would overstate any ability I have, but I've tried to develop some aptitude in that regard. I don't know that, again, I don't want to overstate it. There are people out there who are amazing woodworkers, but I have been trying to do some woodworking, but a lot of hiking, spending time with my family, enjoying the outdoors, things like that, and trying to make sure that I spend time, making sure that I dedicate and don't spend all my time, well, making sure that I dedicate time to my family.
So that's great. I'm very happy to hear that. As we've heard from many folks, just getting your decisions out on a timely manner could dominate your spare time, and I sure hope it doesn't.
I try to balance it. There's definitely times when I work on weekends, when I work at nights. I mean, I think we all do, and I just try to make sure that it doesn't. I try to keep it in balance where I can get the decisions out in a timely fashion, and provide people the speedy justice that they're entitled to, but at the same time balance that with my responsibilities to my family. Again, I don't want to minimize it because it's a significant issue, but it's certainly a challenge that is not exclusive to being on the bench. A lot of parents, like I said, my children are grown now, but there's a lot of families that have to balance that as well. So I do what I can, and I will say that not having some remote hearing days has minimized the travel time, which has certainly been something that I've taken advantage of. So.
Thank you.
Thank you.
Okay, thank you. Senator Nitka, you have some questions?
I just was wondering, you've been in the criminal justice system for a long time now, and here you are still in criminal court doing a lot of stuff. Some of the things seem to have really changed in terms of who gets a sentence where they might go to jail or do a few days. And one of the frustrating things that some judges in the past have said as well, I gave this person a sentence, and the next day I'm on my way home, I stop at the store, and there's the guy in the store buying a beer. So are you finding that people are getting out of the sentence that you gave them if it involved any jail time too quickly, or don't you know what happens to them?
I have not had that experience as a judge. I do know what you're talking about. I have heard that anecdote, not necessarily amongst judges, but I've heard it over the years. I've not had that experience where someone was sentenced to an amount of time and then they were not where they were expected to be. I've just not had that experience. On the other hand, I will say that there's a lot of sentencing alternatives now that they're being used, and I've not had that experience. So.
So on something similar, I was in the grocery store the other day in line, and two people in front of me were talking about somebody who had committed an offense. And the woman said, well, she goes, that guy will get a slap on his wrist and he'll be out. And, I wonder, do judges ever think about doing any PR, or could you, with regard to just general information out to the public as to how things work and why people might be out so quickly? I mean, it seems like, it may not even be the judge's fault that someone's out, but, that's sometimes you take the blame for it. I don't know if there's a way to create a more positive feeling about what's going on in the judiciary.
I don't know. I don't know that there's, I know that Justice Carroll wrote, I want to say Justice Carroll wrote something some time ago about bail and how,
Oh, yeah.
and under the circumstances under which bail could be imposed and when it couldn't be imposed. I don't know if there's really a good opportunity or method for the judiciary as a whole to talk about that. I do try in a decision, in decisions that I reach and the decisions that I make, I do try to explain why I'm making them, as you know, so that someone who might, you know, be listening would understand why, you know, the decision is what it is. And you know, I will on occasions point out that bail is only can only be imposed in certain circumstances, can only be imposed to mitigate the risk of flight to avoid prosecution, cannot be imposed as punishment or as for public safety, cash bail, that is. I don't know what more the judiciary could do. I mean, certainly it is, you know, I certainly am aware that on occasion that that sentiment has been expressed, but I don't know that I have an answer, unfortunately, as to how to resolve that issue.
Just one other thing. I don't know if you're able to comment on this, but do you have any thoughts on changing the 12-person jury to a smaller number? I mean, I know that, I guess in certain cases, if both sides agree, you can do that. But in cases where they haven't agreed, you know, this is moving around the State House. That's why I don't know if you want to comment on it, but.
Yeah, I haven't really given it a lot of thought, honestly, and I don't know that I can comment on it.
Okay. So I think, let's see. Okay, well, I think everybody's asked a lot of what we want to know about you. So, and thanks for doing all the work on getting all your reports in and everything. Appreciate it.
Thank you.
Thanks, Chip.
Thank you, Senator. Senator McCormick, are you there?
Yes.
Okay.
Yes, sorry. I'm feeling sort of like Senator Benning. I don't know what there is to add. You're a rock star. There's,
very
yes.
kind.
I mean, many comments where the answers are all, the ratings are excellent or very good, and the excellents outnumber the very goods. The closest thing, except that I think there were only 3 respondents for the non-lawyers, which is not statistically significant. 1/3 of that is to say one person said that you don't do a good enough job encouraging alternative settlements. That's all I have to give you a rough time.
So I did see that. I did also, I mean, I didn't know what to make of the fact that there were only 3 respondents in that in that group. I did notice that as well, but I wasn't sure exactly how to address it. I mean, the one thing I will say is that I've been in the criminal division now for a little more than 2 years. I think it's been a little more than 2 years, because this is my 3rd rotation in the criminal division, and it can be challenging. I mean, first of all, there's not a lot of alternative resolution in the criminal division. There was a pilot project at one point, but and trying to get involved as the judge in plea negotiations is something that is it's challenging under the rule, because if the judge does get involved in plea negotiations, there are rules about how that has to be done. So it's, at least in my experience, I try to encourage alternative resolutions. I do give the parties an opportunity to settle. It is certainly something I can do more of in the family division. And I certainly do more of that in the family division. But in the criminal division, again, it's hard to know exactly what context that comment came out of.
Yeah.
But I can imagine easily in the criminal division, it's just it's a challenge to be very proactive in terms of negotiation in the criminal division. But I did notice that as well, and it did not go unnoticed by me. Thank you. But it is something that I want to address as well.
Well, now that we've cleared that up, I think you've gotten congratulations on such a good set of reviews.
Thank you.
Thank you, Senator McCormick. I know it's getting late, but I do have a few questions for you, Judge. I spent 35 years of my career as a criminal defense investigator covering all three counties in the Northeast Kingdom. And in fact, I date so far back that Senator Benning was a lowly intern in our office and we shared an office together. So that's how far we go.
Just for the record, Mr. Chair, I want it noted that my first job in that office was to wash the dishes.
Well, I wouldn't have brought that up, Joe, but so one of the few things that interest me, one of my former colleagues, Attorney Slay, has gotten 2 or 3 cases dismissed up in Orleans County for lack of speedy trial, and we have touched on the delay in our court system due to the pandemic. And we understand the rules, but in all 3 cases, I believe they were defendants that were incarcerated as a result of motor vehicle offenses and really non-threatening events. And I'm wondering if you have had the same type of motions and what you may have ruled on or what your thoughts might be on speedy trial issues that are constitutional as it pertains to the pandemic.
So let me answer that. I don't know that I can get into a lot of detail. Let me address it this way. One of the things I will say about the Rutland docket is that of the 10 jury trials that we have tried, they've not all been incarcerated defendants. And the reason for that is because we have not had, I don't want to say this, when an incarcerated defendant is looking for a trial, we've been able to provide that trial when they have wanted it for the incarcerated defendants. That hasn't been true for all of the defendants. I'm hesitating only because I don't recall a time when I believe that we have been able to get the incarcerated defendants to trial timely, which is one of the reasons why on occasion we've had trials, we've had more than one trial of a non-incarcerated defendant, because all of the incarcerated defendants either weren't ready for trial for various reasons. So it's certainly an issue. It's certainly something that we are very cognizant of. The incarcerated defendants get top priority on the trial list. But one of the things I can say, even though the Rutland list in general is large, I'm not hearing, I don't recall seeing, I know I saw one speedy trial motion, but it was a while ago now, and I don't believe it was an incarcerated defendant. But I believe that we are getting the incarcerated defendants to trial such that when we have trial dates that we can draw non-incarcerated defendants even. So I think that's the best I can answer that without talking about specifics.
I don't mean to put you on the spot, Judge. I know that Rutland was one of the first jurisdictions that started to have trials, and Orleans is the last, and that's due to the courthouse situations, as you mentioned earlier in your report. So yeah, I think that needs to be considered as well. So I didn't mean to put you on the spot. But you did mention DREs in your somewhere in your comments, and I guess just a brief question is that an effective system? A lot of discussion happened during the legalization of cannabis discussions that went on for 2 or 3 years here in the State House that were talking about DREs, and it's my recollection that convictions were coming as a result of their testimony, and that jurors were pretty tuned into what they had to say on the witness stand. Is that your experience?
I cannot recall presiding over a DUI trial involving a DRE. I take that back. I think I can only think of one. So I really am not in a position to
Okay,
say.
fair enough. And just for your information, today reported on the floor a bill that came out of our committee, H477, which will allow family members of alleged victims of crimes and restraining orders and stalking orders to have paid time off in order to go to court with family members. I just thought I'd get that out there because it may play an important role in having support for your victims while in the courthouse. And that's all I have.
Thank you.
Anything else? Okay, thanks very much, Judge Fenster. And that, I think, does it for the evening for our interviews with the judges. And we did want to speak a little bit about some committee business before we adjourn for the evening, but that's it for all the parties concerned. And thanks very much for all you for coming.
Should I take us off live?